My name is Bence Udvarhelyi. I am working at the University of Miskolc Faculty of Law, Institute of Criminal Sciences as an assistant professor. My field of research mostly covers questions in connection with European criminal law, protection of the financial interests of the European Union, fight against economic crimes, money laundering, and so on. Therefore, like my Hungarian colleague Roland, this topic is a bit strange for me as well, but it was a nice challenge and an interesting research to get into the details of this question. The topic of my presentation is sentencing policies in Hungary, theory, law, and practice. Let's begin with the theory. When we intend to speak about sentencing, the starting point has to be the definition of the criminal sanctions, which is one of the basic definitions of criminal law. Here we can cite the definition of Professor Ferenc who stated that a criminal sanction is a legal disadvantage defined by law, which, as a general rule, the courts, or in some cases the prosecutor's office, applies against a perpetrator of a crime or criminal illegal act in order to protect the society and deter them from committing a crime under conditions and procedures defined by the law and which the state can enforce through coercion. From this definition, we can now deduce the concept of the sentencing, criminal sentencing, which means a complex evaluating process in which the courts, or in some cases the prosecutor's offices, determines the nature and the extent of the criminal punishment against the perpetrator of a crime as a legal consequence for the commission of a criminal offense during a criminal procedure within the framework defined by law. This framework is the 7th chapter of the Hungarian Criminal Code, which contains the most important general and special rules in connection with sentencing. In this context, it's worth highlighting that the Hungarian Constitutional Court also dealt in several judgments or decisions in connection with criminal questions and sentencing. And the Constitutional Court stated that the rules for imposing punishment defined in the criminal law is representing, in every case, the penal policy of the state. Before we go into details of the sentencing policies in Hungary, we have to briefly present the three main characteristics of the Hungarian criminal sanction system, which has important consequences in connection with the sentencing as well. First, the Hungarian criminal law has a so-called dualistic sanction system. It means that it distinguishes between two categories of criminal sanctions, penalties and measures. Several distinctions can be made between the two categories, but I don't have time to analyze them in details. In the slide you can see the different type of penalties and measures which can be imposed according to the Hungarian criminal law. Secondly, the Hungarian criminal law has a so-called relative definitive sanction system. It means that the criminal code defines the type of the sanction and also its amount, which means the lower and or the upper limit of the applicable sanction. Here, both the general part of the criminal code and the special part of the criminal code regulates the framework of the criminal sanctions. The general part of a criminal code defines the general minimum and maximum of the different types of penalties. For example, in case of imprisonment, the criminal code states that the minimum and maximum duration of the fixed term imprisonment are 3 months and, as a general rule, 20 years. The special part of the criminal law defines the special minimums and maximums of the imprisonment which can be imposed for the different criminal offenses. So, the special part of the criminal code lists the different criminal offenses and stipulate the minimum and or maximum term of imprisonment which can be imposed on the perpetrator of the different crimes. For example, in case of homicide, the minimum term of imprisonment is 5 years and the maximum term of imprisonments are 15 years. This relative definite sanction system has a great importance for the sentencing as well. And thirdly, it also can be stated that the Hungarian criminal law has a so-called imprisonment-centric sanction system. It means that almost all of the criminal offenses in the special part of the criminal code has to be punished by imprisonment. However, it doesn't mean that the Hungarian criminal code doesn't give the possibility for the imposition of milder sanctions. In the general part of the code, we can find a rule that if the criminal offense committed by the perpetrator has a minimum sentence of less than 1 year of imprisonment, the court is entitled to prescribe not imprisonment but other sanctions, fine, community service, and so on. And now let me tell some words about the sentencing principles and the factors the court has to take into account when determining the type and amount of the criminal sanction. In this case, Section 80 of the Hungarian Criminal Code has a great importance, which states punishment shall be imposed within the framework provided for in this act, having in mind its intended objective, as consistent with the severity of the criminal offense, the degree of culpability, the danger of the perpetrator represents to the society, and the other aggravating and mitigating circumstance. This provision contains the 6 most important factors the law enforcement authorities have to consider during the sentencing. First important thing is the objective of the punishment, which is also regulated by the criminal code. Section 79 of the criminal code states that the aim of the punishment is to prevent the perpetrator or any other person from committing an act of crime in the interest of the protection of the society. It means the Hungarian criminal code lists 3 main objectives for the punishment: the protection of the society and the so-called general and special prevention. The second important factor is the framework provided for in the Act. As this is what I was speaking about, that the Hungarian Criminal Code contains the general and the special minimums and the maximums in connection with the criminal offenses. The courts and the law enforcement authorities have to take into account these frameworks, and the sanction has to be, as a general rule, among the minimum and the maximum. However, I will speak about it a bit later, the special minimum and the maximum can in some cases be exceeded. The third factor is the severity of the criminal offense, which means the degree of the harmfulness of the criminal offense to the society. The more dangerous the criminal offense is, the more severe penalties can be imposed on it. Fourth, the degree of culpability. In this context, the courts have to take into account whether the commission of the crimes was intentional or negligent. If intentional, was it committed with dolus directus or dolus eventualis, or in case of negligence, the 2 types of negligence, luxuria or negligentia. The fifth important thing is the danger of the perpetrator represents to the society. In this case, the courts has to consider, for example, the perpetrator's social background, lifestyle, family relationships, the behavior before and after the commission of the criminal offense, and so on. And finally, the court can consider any other aggravating or mitigating circumstance which it considers important and relevant in the criminal case concern. Here just some examples. For example, aggravating circumstance can be previous conviction, drunk commission, joint commission of the crime, persistent intent. Mitigating circumstance can be the attempt, the contribution of the victim in the commission of the crime, the compensation of the damage, and so on and so on. According to the Hungarian Criminal Code, the sentencing as a general rule has to be fulfilled with the so-called median sentencing. It means that if the Criminal Code prescribes imprisonment, fixed-term imprisonment, the median of the prescribed scale of the penalties has to be applicable. The median is the half of the sum of the lowest and the highest penalty to be imposed. For example, in case of intentional homicide, the minimum is 5 years, the maximum is 15 years, the median is, in this case, 10 years. Of course, it doesn't mean that the court has to prescribe 10 years of imprisonment in each case of intentional homicide. It's only a starting point, and based on this starting point, the court can evaluate the aggravating and the mitigating circumstance. The justification of the Criminal Code also shows this context because it states that this general rule doesn't mean to neglect or narrow the possibilities provided by the framework, and it doesn't make the penalty system absolutely defined, nor it does create a mandatory penalty situation. Therefore, the discretional power of the court remain unchanged in this case as well. As I have already mentioned, the general and the special minimum maximum have important role in the sentencings, since it determines the amount of sanction to certain extent. However, in some cases, the Hungarian Criminal Code provides the possibility to exceed the minimum and the maximum. There is the possibility in the Hungarian Code to exceed the minimum, so the lower scale of the penalty. It means the mitigation of the sentence. According to the Criminal Code, if the minimum sentence prescribed by the Criminal Code is deemed to be too harsh based on the principle of sentencing, the Criminal Court can use less severe punishment. For example, if the minimum is 10 years, it can go to 5 years, if 5 years to 2 years, and so on and so on. Furthermore, there is also possibilities to exceed the maximum of penalty. There are 4 cases in this context: the cumulative sentence, the 2 type of recidivism, and the commission of the crime within the framework of a criminal organization. This topic was partly analyzed by Roland, so I don't want to speak about it in detail. The most important thing in connection with that is that in case of cumulative sentence and in case of habitual and repeat offenders, the upper limit of the punishment has to be increased by 1/2 of the maximum penalty. So, for example, if in case of a robbery, which is punishable by 8 years of imprisonment, the maximum has to be 12 years. In case of violent repeat offenders and criminal organization, the upper limit has to be doubled. So instead of 8 years, 16 years can be the maximum punishment. However, the maximum of the punishment must not exceed 21 years, which is the absolute general maximum for the punishment. And in case of violent repeat offenders, there is the mandatory imposition of the life imprisonment if some other criteria met. And now, since the topic of my presentation states that I will speak about the practice, you can find some statistical data which I tried to show. The table was a bit broken, but hopefully the most important things can be seen. These are statistics from 2021. In 2021, approximately 55,000 perpetrators were convicted, and more than 90,000 sanctions were imposed to the perpetrators. Why are the two numbers different? Because according to the Hungarian criminal system, with some exceptions, criminal sanction can be applied cumulatively. So it can be possible that one perpetrator is sentenced for 2 or more criminal sanctions. Unfortunately, we cannot see the upper line, but we can here see the percentage of the penalties and the measures. Almost 80% of the applicable sanctions were penalties, and slightly more than 20% were measures. And which is interesting that in Hungary, not the imprisonment are the mostly applicable sanction, but the fines. So almost 1/4 of the cases were finally adjudicated by fines. The second highest rate has the imprisonment, which a bit less than 20%. And among the penalties, the driving ban and the community service has a higher number. Of course, this 20% rate of imprisonment can be seen a bit high, but if we look at a bit in details, we can see that among the fixed-term imprisonment, more than 60% was so-called suspended imprisonment, which means that the perpetrator doesn't have to go to the prison system immediately, but was sentenced for a conditional sentence. And only 38% of the fixed-term imprisonment was the so-called executable imprisonment, which is a bit lesser amount than the total number of imprisonment. The number of life imprisonments were in 2021 very low, only 20 cases, but almost half of them was life imprisonment without the possibility to release on parole, which means the actual life imprisonment where there is no possibility to be released. And if we would like to see the length of deprivation of liberty, that was from the prison statistic I mentioned at the end of the previous section, it can be seen that the most common term of imprisonment was between 5 and 10 years. Then the second was 3 and 5 years, which seems a bit strange. It can be concluded that the Hungarian courts don't impose very often executable terms of imprisonment, but if they do so, the term of imprisonment is quite high. So we can see that almost the half of the imprisonments are 3 to 10 years, and the imprisonment of more than 10 years have also a quite significant number with more than 2,000 or almost 2,000 members. Of course, we can cite other statistics as well, but I think my time comes to the end. Therefore, I want to thank you for the attention.